Mr. Gutierrez, I have before me in cause number M324403 an information that alleges that on or about July 25th of 2019, while you in Jefferson County, Texas, operating a motor vehicle in a public place, that you, Ruben Gutierrez, committed to Class B misdemeanor offense of driving while intoxicated. Mr. Gutierrez, do you understand what you've been charged with?
Yes, sir.
And to this charge, I don't think I was just looking at the plea agreement. I think by statute, deferred is only eligible on or after September 1 of 2019. This offense occurred July. I just like this, July 25th of 2019. Yeah, so it was before that statute.
My understanding was, I thought it was after the date, Judge.
No, the offense this July, July, August, September, yeah.
By 2 months?
Yeah, this is before that date.
I didn't even realize it.
Yeah.
So, I mean, so we can, whatever the court do, I can give another offer, Judge, I can reset it and give another offer. It's up to whatever the court.
I mean, right now, I can't go along with the offense, I'm sure.
No, I don't.
Yeah.
Yeah, and that's, but no, I was unaware of it.
I wasn't aware that it was.
I would ask, could we reset it so I can check on the issue and then we'll enter a plea or try it if we could reset it.
That's fine with me, Judge. I just, it was both of our understanding it was that it could be, now that you can't accept the plea offer. We're asking it to reset this.
Yeah, because the offense date was before the date of the enactment of the
That's fine.
statute.
Give him time to look at if he has an issue. to look
Yeah, that
into.
statute's not retroactive.
Whatever we need, but we will reset it one time.
Okay,
And then we're ready to go forward with our next case.
okay, let me do this.
I'll explain it to you, but I was unaware.
Okay, just have a seat. We'll have our court administrator to give you a reset.
Thank you.
More questions?
Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for inclusion as jurors in a criminal case. The cases that we handle here in County Court at Law Number 2 are classified as misdemeanor cases. It's a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are they refer to as your more serious type offenses, whereas your criminal cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, I'm talking about the nature of the offense, that's the facts, as well as the punishment. That is what a person can get for punishment in a criminal case or in a criminal felony case. Now, you have been asked, as I said earlier, to come here this afternoon for inclusion on a criminal jury trial. Before I get any further, I'd like to introduce myself. My name is Judge Terrence Holmes. I'm the presiding judge here in this court. Our courtroom hours are normally from 9 a.m. to 5 p.m. Now, whether or not you're selected for inclusion on this case, just be mindful that you are serving or performing a significant service that only free people can perform. If you're selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for meals, and at night. Now, I must perform the first of two administrative functions. The first function I must perform, I need every one of you to raise your right hand so that I can administer the oath to impanel you. And at the end of administering the oath, I need to have each and every one of you to say, I do. Do you and each of you do solemnly swear or affirm that you will true answers to such questions as may be propounded to you by the court or under its direction, touching your service and qualifications as a juror, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions that you may wish to claim. First, I will determine whether or not you're qualified to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and a lawyer or I discover that you have not been truthful, then the case could be retried and you can be held in contempt of court and placed in jail for up to 180 days, and you could be given a fine up to $500. Now, the way I will ask the questions, I would ask the question and then I need you just to answer to yourself. And then once I finish asking the last question, I will then ask, is anyone here disqualified under the law? And if you think that you may be disqualified under the law based on your answers to one or more of the questions, then just simply raise your hand. And then once you raise your hand, we're going to ask that you will come forward so that we can discuss the matter more privately. And what I mean by more privately, I have a device here that we will place on so that no one else will be able to hear the discussion here at the bench. First question, except for failure to register, are you a qualified voter in Jefferson County and in Texas under the Constitution and laws of Texas. Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause here before I ask the next question. The next question that I'm required to ask by law, I'm not trying to meddle into your personal affairs, it's just that this question has to be asked. And the question is as follows. Are you presently insane, and have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Or you're a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Now, that was the last question. Now, is there anyone here who is disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Let the record reflect that no one have raised their hand. Now I will proceed to exemptions. I will determine if any one of you who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. Now, the first question, it will be asked in the same manner. You just answer to yourself, and then at the end, we'll ask whether or not if anyone would like to claim any one of the exemptions. Number one, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public, private, secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home and out of Jefferson County? Is there anyone here on our panel who would like to claim any one of the exemptions? Okay, we have one person. Is that Eunice Windsor?
No, Sarah.
Hmm?
Sarah Citizen.
Hold on a minute. Hold on a minute. Okay, I see what happened. Miss Citizen. I think I seated you wrong. You drew number 16. I think 16 is over there. Okay, where is where's Sharon? Okay, you Sharon, okay. Oh, that's 19. I see what happened. Hold on a minute. Get my chart. You have your chart. I think on the back row, let me see, we got Thomas, excuse, we got Slayton, Fleming, and Perez is not here. Fitzgerald. Okay, Rowan. Kiker is not here. And Williams, right there. Okay, let me go back to there. That Hemmings. Randall. Clifton. Grinning. Styles. Right there. Low. Velez. Oh, let's see, yeah, Citizen is supposed to be where Mr. Sharon, Mr. Sharon, you're supposed to be in the chair behind you. Yeah. And Citizen, you're supposed to be in the chair where he's sitting. That's 16, that's Citizen. Okay. 17 is Young. 18 is Windsor. 19 is Sharon, yeah, okay, she was, okay. Okay, so that's, we have Ms. Citizen, you raised your hand, is that correct?
Yes, sir.
Okay, you like to claim an exemption, would you please come forward? You need attorneys. Soft. Okay, is there anyone else who'd like to claim an exemption? Let the record reflect that no one else is claiming an exemption. Now we'll move on to excuses. If any of you feel there's a reason why you cannot fit on the jury, then you may claim one of the following excuses. A juror may be excused for observance of a religious holiday upon the completion of an affidavit, and that's pursuant to Article 29.012C of the Texas Code of Criminal Procedure. A person may not be excused for economic reasons without the consent of the parties. That is, you cannot be excused without the consent of the state and the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here who would like to claim an excuse? Let the record reflect that no one is claiming an excuse. So at this time, everyone on the panel is qualified. No one is claiming an excuse and no one is claiming an exemption. And so at this time, before we start the voir dire process, we're going to take a recess. So we need everyone to go out into the hallway, and then the bailiff is going to get you to come back in a few minutes. Please follow the bailiff.
Where are you posted to?
Okay, Jefferson County Court at Law number 2 is now in session. The court is in session in 2 cases. First case is cause number M331052. Second case is cause number M332564. Both cases are styled the state of Texas versus Kellen Deontay Grogan. Mr. Grogan, is that your full name?
Yes, sir.
Mr. Grogan, you're here represented by your attorney Langston Adams. Attorney Adams, how are you doing?
Doing well, Judge.
And the state is represented by attorney Kobe Harper. Attorney Harper, how are you doing?
Good, Judge.
Mr. Okay, state, are you ready?
State Judge.
Defense, are you ready?
Yes, yes, sir.
Okay. The court in cause number M332564, Mr. Harper, you'd like to read the information? Please present the information.
Might give me that number.
M331052.
No, the first one I just called was M332564.
Oh, I'm sorry. M332564.
Cause number 332564, the state of Texas versus Kelly Deontay Grogan. Information in the name by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Kelly Deontay Grogan, hereinafter styled the defendant heretofore on or about April 11th, 2022, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Ashley Renee Neal. Hereinafter styled the complainant by grabbing complainant around the neck and pushing the complainant onto the floor. And at the time of the said assault, complainant was a member of the defendant's family against the peace and dignity of the state, signed by the undersigned Assistant Criminal District Attorney.
Mr. Grogan, how do you plead? Not guilty? Or not guilty? Okay. State, are you?
We'll waive open and we'd have to call our first witness, you know.
Okay, you waiving opening as well? Okay, you can call your first witness.
State calls Ashley and Renee Neal.
No response on Ashley Neal, Your Honor.
Do you have any other witnesses?
No, Your Honor, state arresting closes.
State, defense, you have a motion?
Directed verdict.
Okay, court is going to grant an instructive verdict in this case. Mr. Grogan, you've been acquitted of the charges in cause number M332564, and in a few minutes, you'll be able to get a copy of that judgment. Next case is cause number M331052. Case is styled the state of Texas versus Kelly Deontay Grogan. State, are you ready?
Yes, Your Honor.
Defense, you ready?
Yes.
State, would you like to read the
Yes,
information?
Your Honor.
You may proceed.
In cause number 331052, the state of Texas versus Kelly Grogan. Information comes now the undersigned, in the name and by the authority of state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court of law of Jefferson County, Texas, that in Jefferson County, Texas, hereinafter styled the defendant heretofore on or about August 3rd, 2021, did then and there unlawfully with intent to place Ashley Neal, hereinafter styled the complainant, in fear of imminent serious bodily injury, threatened to commit an offense involving violence to the complainant, namely assault. At the time of the commission of the offense, the defendant and the complainant were in a dating relationship against the peace and dignity of the state, signed by the below signed Assistant Criminal District Attorney.
Mr. Grogan, how do you plead? Okay, state, you may present your first witness.
This time, state calls Ashley Renee Neal.
No response on Ashley Neal, Your Honor.
Mr.
Judge,
Yeah.
just for the record, and this applies to both of these cases, the state has tried on multiple occasions to contact Ms. Neal. We've sent subpoenas, letters, and we've called to no response on multiple occasions for multiple trial settings. So that goes for both cause numbers, Your Honor.
Okay, does it,
We rest in
you rest? Okay. Defense,
Move for instruction verdict.
that motion will be granted. Mr. Grogan, you've been acquitted of these charges. You'll be able to get a copy of the judgment in a little bit once the judgment is prepared. Okay, so you're free to go. You have a blessed day.
Thank you, Your Honor. Y'all take it
Mr.
easy. Thank
You're
you.
welcome. Mr. Monty, you could go ahead on and call the jury back in.
Hey, Judge, with your permission, can he take off that monitor thing?
Let me,
There's a form.
yeah, I have an order. We're gonna have
Get it
to,
from Braylon.
yeah, get it from Brella. Okay. You can have a seat in the jury box.
You want to have?
Yeah, because we're getting ready to bring in the jury right now, so.
We gonna use that.
is a Class B misdemeanor. Just going over the punching later, but just as an entry question, have any of y'all been the victims of that case? Um, anyone, anyone accused of that? Did someone say that they were the victim? Ms. Young,
Yes,
would you mind elaborating on
and my purse stolen and in my car.
that? Would, the experience deeply affect you?
Yes,
Would you say that that experience would affect your ability to be fair and impartial in this case?
no,
No. Before we reach some more questioning, and thank you for that, by the way. Before we reach any further questioning, I'm going to go over something that we can discuss at this point, which is the law that's governing this case. In order to make our case, the state is going to have to establish that defendant on or about a certain date in Richland County, Texas, intentionally, knowingly, unlawfully appropriated property, and the value of that property was valued at $100 or more, but less than $750 from the owner without their effective consent, and with the intent to deprive of that owner of property. Going into more detail about the definition, to appropriate means to acquire or otherwise exercise control over the property. Does anyone have any questions about that definition or the elements that I placed on the slide earlier? Now, the appropriation that we just defined is unlawful if is without the effective consent of the owner, or if the individual appropriates property that they know is stolen. Any questions about that? Property is corporeal property, meaning it's tangible. It's something that you can touch, that you can see. In this case, it's consumer goods. So in regard to the evidence that the state is presented trouble, what legal expected in the case of this? Being volunteered? Oh, sorry, I was asking what evidence that you would expect to see in a case like this. Okay, video, like surveillance video, for example. Thank you. That was Ms. Randall from. Anyone else about any particular evidence that you think you would see in a case like this? Any suggestions?
no, I would say the same thing as what
Okay. So, those were just to illustrate, like, in case like this, we often don't have forensics, like some people say to that question that they expect to see some kind of fingerprinting or, some other forensic analysis, but often that's not the case, especially in senior theft cases like this. But what we do have, like, oftentimes, like was suggested on this run, we have security photos, surveillance video. And something that wasn't suggested was that we have eyewitness testimony. The burden of proof, as y'all likely heard, at this point, in either media or just watching trials yourself, is beyond a reasonable doubt. That standard is fairly high standard, but it's not, impossible to beat. It's the standard that all criminal cases in the United States are governed by. And really, what we would need you to do is the common sense, whenever we give you the facts, the finder of fact, to decide if those facts, when applied to the law, make up the elements of the offense. Okay. So, in this image, we have a puzzle. The puzzle's missing a few pieces, right? And we're using this sort of as a metaphor for this trial. Even though the pieces are missing, can everyone in the audience make out what this puzzle's trying to come together? What it is? So, Mr. Clifton, what is that puzzle a picture of? And just to be clear, there's no one who couldn't tell that was going to be Andy, right? So, as I was saying earlier, the law requires that we prove our case, the state proves its case beyond reasonable doubt. But it does not allow us to define that term. And so, which is why we're suggesting that while it's not beyond all doubt, and it's not beyond the shadow of doubt, which is a term of art that doesn't really exist in the system, it's something that is sort of made up in popular media. And you will know it when you see it. That's why we ask that you use your common sense when applying the law to the facts in this case. Would any of you require more of us? No one would require us to prove anything beyond the standard or beyond the reason. No one would hold us to a higher burden than that? Okay. Yeah. Does anyone know either myself or Mr. Hoffbauer? Does anyone know of defendant Kimberly Barton or any member of her family? And does anyone know the defense attorney, Brett Gimler? Judge already went over the punishment range for this case, being a Class B misdemeanor, up to 180 days. Fine includes up to $2,000. Probation is an option in this case for punishment. Okay. So has anyone served on a jury before? How many of y'all served in Jefferson County? And what type of case? We'll go one by one. Mr. Slayton.
Here in Jefferson County, it was a traffic court.
Is a Class C situation. Now, can I get the hands raised one more time? Okay. Ms. Randall, Clifton, and Screening.
Oh, it wasn't.
I'm sorry, Ms. Rowland. And Ms. Young, did you raise your hand? Did I miss anyone? Okay, Ms. Lowe. So, Ms. Rowland?
It was a civil case in Essex County, Massachusetts, involving the University of Massachusetts. It was 15 years ago.
Mr. Clifton?
Jefferson County. I've been on the civil and a criminal.
How long ago was that?
And brother preaching word.
And what was the verdict in the criminal case?
Sorry?
What was the verdict in the criminal case?
Guilty.
Do you remember what kind of case it was?
That's right.
Ms. Brennan?
Yeah.
And about how long was that?
8 years ago, maybe. something like
Do you remember what type of case it was?
that. Theft and abuse of narrative.
And did you ever reach a verdict? Yes. And, what was that verdict? On both counts? And Ms. Love? Criminal. And how long ago was that?
Probably about 10 years ago.
Do you recall the type of case?
Remember that, he was found guilty and, sentenced to probation.
And Ms. Young?
Bear with me, early 80s. It was a rape case. And he was found guilty.
Thank you. Ms. Williams?
Yes.
And you said you served on jury as well?
Yes, there was a criminal case in Judge Stevens Court about 7 years ago. And we did reach a verdict
And what was that verdict?
guilty.
Do you recall what the charge was?
Yes, it was a shooting.
Ms. Fitzgerald?
In excess of 20 years, it was a rape case. And that was not guilty, and then it was a personal injury. You didn't get one.
And Mr. Settle?
Served on a civil case about 10 years ago for part of the personal injury.
Thank you. And this is sort of a blank question. For all of you who served on jury, would that experience affect your ability to be fair and impartial in this case? So, going back to the case that we have before us today. And some more, and this is more of an opinion question. Would the victim of the crime affect your decision making when deciding guilt or innocence in this case? So it wouldn't matter in your mind if the victim was, say, a chain store, private individual or neighbor. And would the type of item stolen in this case affect your decision making in deciding guilt or innocence? This is just illustrating the jury's duty in this case, which is to decide the facts of the case, apply the facts of the law, and then follow the law. Which all of y'all, based on the answers to those questions, seem to be able to do. Now, for any reason, religious or otherwise, is there anyone here in the jury panel that feels they cannot sit in judgment of another? Now, just as a refresher, we're gonna just going over the elements one more time. The state must prove the defendant on or about a certain day in Jefferson County, intentionally and knowingly, unlawfully appropriated property. That's a value of $100 or more, but less than $750, without the effective consent of the owner, and with the intent to deprive the owner of that property. And everyone understands the elements of the case. Are there any questions that you think that I should have asked, given the nature of this case, that you think I should address? Thank you all for your time, and I look forward to presenting this case to you. Whoever the 6 jurors are in this case.
Okay, Mr. Kimlin, panel's yours. You also have 30 minutes.
Afternoon again, just on punishment, the Texas allows a defendant to make an election prior to the beginning of the examination of jury panel for the jury to set punishment in the case. You have to file a written notice that you're going to the jury for punishment versus the judge. If nothing's filed, then if you're by default, you go to the judge for punishment. So for one of the few jurisdictions that allows a defendant to choose whether to go to the jury or the judge for punishment. In this case, we've chosen to go to the judge. So punishment is not an issue for you in this case of the jury in the event of a conviction. Punishment will be set by Judge Holmes. Is Mr. Hugh accurately indicated, it's a Class B misdemeanor. Punishment ranges up to 180 days in Jefferson County Jail and up to, I think, a $2,000 fine. Probation is an option. But all of that will be determined by Judge Holmes in the event the state is able to obtain a conviction in this case by convincing beyond a reasonable doubt that they met their burden of proof on all the elements that they're required to meet. Now, when y'all walked in, I guess you saw Ms. Barton sitting at the table. Did any of you ask yourself, I wonder what she did wrong to be here? Anybody? Mr. Green? No? Ms. Fitzgerald? You did? You asked yourself that? Why'd you ask yourself? Well, why'd you think you did? She did something wrong, criminally wrong?
Because it's here in court.
Well, if I advise you that the law, and I anticipate Judge Holmes is going to instruct you to this regard, if the law states that she's presumed to be innocent, would you have any reason to disagree with that simply because she's been charged with an offense?
Just curious to see what she's done.
Well, so you would be able to presume her innocent. In other words, that she's done nothing wrong at this point, presume that if anything all criminally wrong, it's just a charge, right? Everybody agree with that at this point? The defendant by law is presumed to be innocent. So the fact that somebody's charged with an offense, it's not evidentiary, it's not evident. It's just the way that the jurisdiction of a court in this particular case, a misdemeanor, county court is invoked to bring people in and impanel the jury to hear evidence to determine whether the state's met their burden of proof. That's all the charge is. It's not evidentiary. So if you voted right now, Mr. Slayton, but right, you voted right now, guilty or not guilty, what would your vote be?
Can't know what to say. I haven't heard anything.
Okay, so what would your vote be? You haven't heard anything, what would your vote be?
Yeah, plain to your face.
Well, if she's presumed to be innocent, you're going to establish that with Ms. Fitzgerald. And you haven't heard, ma'am?
I'm Fitzgerald.
Oh, I'm sorry. Ron, I apologize if I get it. We used to have everybody together, it was a lot easier to keep track of names with COVID. Yeah, so you're Fitzgerald and you're Rowan, right? As Ms. Rowan stated, she's presumed to be innocent. You haven't heard any evidence at all. The charge is not evidentiary. You can't infer anything negative about her just because she's charged with offense. If you voted guilty or not guilty, what would it be?
Can't vote. I mean, I haven't heard the states.
I think about it. It's not a trick question. What are they required to do before you can? What do they have to do?
So beyond that of a doubt that their person is.
Well, I like that. I like the shadow of that part. It's not right, but I like it. But have you heard any evidence at all?
That's decided by, no,
Okay.
I haven't heard anything.
Is she presumed to be innocent?
It's presumed to be innocent.
So what's the vote?
Can't condemn her or can't.
If they're required to prove it, they don't prove it. If she's presumed innocent, what's the vote?
Well, yeah, here in the case, yes, if they present the case to me right now,
Right now,
and I'd have to decide which way is,
right now, what would the vote
I can't vote.
be? Mr. Gerald, what would the vote be?
Not guilty.
Not guilty. It's not hard. You're making it too hard. For Dr. Slayton, I guess. Yeah, you're the doctor. Oh, that was Thomas. See, that was the former number one we had. I'm not promoting it. Yes. Blake, retired.
Retired.
Still working
Exxon,
at Exxon, rotating equipment. What's that?
work on pumps, compressors,
Okay.
stuff like that. Troubleshooting.
So. Does anybody disagree, you include Mr. Slade, do you disagree with Ms. Fitzgerald, that right now it's not good?
Yeah.
You see that?
Yeah, I do see what you're saying. I mean,
Do you agree with that?
but right now I don't have an opinion because I haven't heard it.
Well, you have, if they haven't offered you any evidence, she's presumed to be innocent, what does it have to do?
After the case has been handed to the jury, then I'd make a decision.
Well, I'm saying right now, right, she's presumed to be innocent right now.
Yeah.
Is innocence the same thing as not guilty? Mr. Sharon, what do you think? Is innocent the same thing as not guilty? How many people agree with Mr. Sharon? Innocence is the same as not guilty. Mr. Velez, is that right? Please, is that correct? Velez, I'm talking about, that's the correct pronunciation? I'm sorry. All right, well, people get my name wrong. But do you agree with that, that innocence and not guilty are the same thing? Now, what's the difference?
Innocence is not that you and your charges, whereas not guilty, there is not evidence.
Exactly. That's perfect, exactly. Innocence means you didn't do it, you're clear, DNA, it's not you, those would be in certain rape cases, right, you got DNA. A lot of people were wrongfully convicted before DNA forensically was available to analyze, physical evidence. People have been cleared years after the fact, you didn't do it, it's not your DNA, we know that you're innocent. And that differs from not guilty in that not guilty is a failure of proof. I mean, was OJ innocent? Was OJ not guilty? Yeah, he was not guilty. Right? Do you think that, okay, well, we back up. So not guilty means what? That there's a failure of proof, there's doubt, there's reasonable doubt. Does everybody get that, right? Innocence is not the same as not guilty. Not guilty is if there's a reasonable doubt that you have. That one of the things that required to prove you have to. Not guilty. Now, does guilty mean on the flip side of that, does guilty mean that the person 100% for sure committed the offense? Right, because it's not certain, it's not absolute certain, and you can't have absolute. Well, how high of a standard of proof is beyond a reasonable doubt? It's not absolute certainty. How close to absolute certainty is it? Yeah, but not absolute, somewhere close to absolute. Would you agree? Now, Judge Holmes is not going to do you favors by giving you a definition of proof beyond a reasonable doubt. Each of you are going to have to determine for yourselves how high the burden of proof that is. And you can go back in the jury and have 6 different opinions on how high the burden of proof beyond a reasonable doubt is, and all 6 of you will be convinced. I would just simply suggest to you that even though it's a class 2 misdemeanor, there's a possibility of 6 months in jail, and how sure do you want to be on that determination, on that call? A person potentially be deprived of the freedom for 6 months in Jefferson County jail. And again, in any criminal case, it's the same, referral from the traffic ticket on up to capital. So I would simply suggest to you that it's a high standard of proof. Obviously, it's not an awful standard of proof. People convicted every day across the country on that standard. But considering what's at stake with somebody's freedom and liberty, I would hope that each of you would give it a serious consideration to hold the state to that high standard. Do you like disagree with that? Okay. I don't know at this point, obviously, defendant can take the witness stand and testify on their own behalf. That's usually the call that's made, after you hear the state's evidence. In the event that the defendant doesn't take the witness stand and testify, there'll be an instruction given to you that you're not to consider that in any way, either for or against the defendant. Just you can't consider it. Would all of you be able to follow that instruction in the event the defendant does not testify? did not consider anyway? Or would any of you hold that against Mr. Gardner if he doesn't testify? Mr. Slade, what do you think?
I would know.
Anybody, Mr. Hennings, is that right, Hennings? Hennings, I'm sorry. Hennings, what do you think? Somebody doesn't testify?
I wouldn't hold against.
So everybody will be able to follow the court's instruction. Again, this is a theft case. Mr. Hugh will present some slides on that. One thing, actually, this kind of helps them, but it's not the owner of the property, it's somebody that has a superior right of possession. That's what they have to prove. I don't think Judge Holmes is actually gonna charge, you may, I don't know, on the charge itself, it's a superior right of possession. Not through owners, it's somebody that has a superior right to possess the property when the person is accused of a law. Necessarily. Any of you have any questions for me? No? Okay, well, thank y'all.
Okay, ladies and gentlemen, we're gonna ask that you follow the bailiff into the hallway now. We might have to call some of you back in to do some follow-up questions. So at this time, please stand and follow the bailiff into the hall.